Welcome. I'm Elena Park. Today we're going to spend a long, close hour together. Well, not literally an hour, but enough time to walk through one Supreme Court case that, in many ways, defines modern Fourth Amendment law, Katz v. United States. This is the case that moved the law from a narrow, property-based view of searches into a privacy-focused framework that still shapes debates about surveillance, phones, and data. So let's begin. First, the Fourth Amendment itself, the baseline. The text, ratified in 1791, says, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." You know the rest. That language reflects an 18th century world where the main threat the framers feared was physical rummaging, general warrants, writs of assistance, officials who could search a home for smuggled goods without particularity. But fast forward a century and a half. By the late 19th and early 20th centuries, communication technology had changed everything. Telegraph, telephone, messages traveled over wires and through centralized networks. Law enforcement found ways to intercept without physically entering a home, and the courts were slow to catch up. For decades, the doctrine focused on physical places, whether the government had intruded into a house, a paper, an effect. If there was no trespass, it often wasn't a Fourth Amendment search. Olmstead versus United States, 1928. That's the key background case. Roy Olmstead was a bootlegger in Seattle. Federal agents clipped wires and tapped his phone lines from public streets. They never entered his home or office. The Supreme Court, Chief Justice Taft writing for a 5-4 majority, held that these wiretaps did not violate the Fourth Amendment because there was no physical trespass into a protected place. The Fourth Amendment protected material things, not intangible conversations traveling along wires. Brandeis dissented. And oh, what a dissent. He said the Constitution must protect the right to be let alone. He warned that technology could enable invasions the framers couldn't imagine, so the law needed to be elastic. For decades, Brandeis's voice was a minority one, but it was also prophetic. Now, pause. Enter Charles Katz. Who was he? Not a heroic figure. Katz was a sports bettor, a bookmaker, described by some accounts as a leading college basketball handicapper in mid-1960s America. He moved large sums of money between bettors and bookmakers across state lines. Importantly for our story, he used public phone booths to make calls to Boston and Miami to relay bets, lines, and odds. Picture the booth. Glass panels, a sliding door, a metal frame, on a busy corner of Sunset Boulevard and La Brea in Los Angeles. Katz would walk down the sidewalk, step into the booth, shut the door, drop coins into the slot, dial, and speak into the handset. The door muted the traffic. It felt private. That's crucial. The FBI was watching. They had intelligence connecting Katz to an interstate gambling enterprise that violated the Wire Act, 18 U.S.C. Section 1084, which criminalized the use of wire communication facilities to transmit wagering information across state lines. The agents needed proof, what was being said on those calls. But following Katz or watching him only got you so far. It didn't capture words. So they attached listening devices to the outside of one of the booths Katz used. Important technical detail: the agents did not go inside the booth. They did not tamper with internal wiring. No one physically entered Katz's property. Instead, they affixed small microphones to the booth's exterior. The devices picked up vibrations through glass and metal and recorded the conversations on a reel-to-reel tape recorder in a car or nearby. This surveillance ran for 6 days in February 1965, February 19th to 24, and produced recordings of Katz relaying wagering information to contacts in other states. Then, on February 24, the FBI arrested Katz. He was indicted under the Wire Act. At trial, the defense moved to suppress the recordings, arguing they were the product of a search and seizure under the Fourth Amendment, conducted without a warrant. The government said, No physical trespass, no search. Olmsted controls. The trial court denied the motion. The tapes were admitted, and Katz was convicted. He appealed to the Ninth Circuit, which affirmed. The appellate court echoed the property-based reasoning. There had been no physical entrance into any area occupied by Katz. So long as the government avoided a trespass into a person's home, office, or personal effects, wiretapping from the outside was not a Fourth Amendment search. That was the law until the Supreme Court took the case in 1967. Why did the Warren Court take Katz? By the mid-1960s, the court was already rethinking criminal procedure, the exclusionary rule, Miranda, and so on. Technology kept advancing. The question the court accepted was, does the Fourth Amendment cover electronic eavesdropping that does not involve physical trespass? Or does the text's emphasis on persons, houses, papers mean the property rule still governs? Oral arguments are always a highlight for law students. October 17, 1967 in this instance. The government's position was straightforward. Under Olmsted and related precedents like Goldman v. United States, non-trespassory electronic surveillance falls outside the Fourth Amendment. Also, the phone booth was on a public street. Anyone could use it, and Katz had, in a sense, exposed his voice to the public. Therefore, no reasonable expectation of privacy, they argued. But Katz's lawyer, Harvey Schneider, said something simple and profound. The Fourth Amendment protects people, not places. That phrase, people, not places, comes from the opinion the court issued on December 18, 1967. Justice Potter Stewart wrote the majority opinion in a 7-1 decision, reversing Katz's conviction. The holding? When Katz entered the booth, shut the door, and paid to make a call, he manifested a subjective expectation that his conversation would be private, and society is prepared to recognize that expectation as reasonable. The FBI's electronic eavesdropping, conducted without a warrant, was therefore a search and seizure under the Fourth Amendment. Justice Harlan's concurrence is the bit where doctrine really hardened. He offered the two-part test that courts still invoke. First, did the individual exhibit an actual, subjective expectation of privacy? Second, is that expectation one that society is prepared to recognize as reasonable? That's the now familiar Katz or Harlan test. Brief interjection. Hugo Black dissented. He stuck to the text. The Fourth Amendment protects persons, houses, papers, and effects. Black warned against creating a free-floating right to privacy untethered to the text. He worried the majority rewrote the Constitution. His voice would be heard again in later debates. Okay, so Katz reversed Olmsted's core holding and moved the law toward expectations of privacy. The immediate institutional fallout was real. The FBI and other agencies had to revise surveillance protocols. Electronic eavesdropping generally required a warrant when aimed at communications where people had a reasonable expectation of privacy. Congress responded too. In 1968, the Omnibus Crime Control and Safe Streets Act included Title III, the Wiretap Act, which set out detailed warrant procedures for wiretaps and bugging, with minimization requirements, reporting, and limitations on duration. And Katz himself, there's an ironic, almost tragic coda. Katz's conviction based on the illegally obtained tapes was overturned, but he was re-indicted and later convicted again, this time with evidence gathered under proper procedures. He served prison time. So the man at the center of the case didn't walk off into civic sainthood. Instead, his name lives on in constitutional doctrine. Katz lost a personal battle, but won a constitutional war for the rest of us. Let's pause. You might be thinking, okay, this is all very legalistic, but why does Katz matter today? Because the Katz framework, Justice Harlan's two-pronged test, became the central tool for asking whether the Fourth Amendment applies to new technologies. It shows up in cases about workplace files, thermal imaging, GPS trackers, smartphones, and cell site location data. Short example, Mancusi v. DeForte in 1968, right after Katz, applied the reasonable expectation idea to a union official's workplace records, even though he didn't own the office or have exclusive control. The point, privacy expectations can arise without strict property rights. That's Katz's legacy in action. Jump to Kyllo v. United States in 2001. Agents used thermal imaging from the street to detect heat patterns in Danny Kyllo's home, consistent with grow lights for marijuana. The court held that using a device not in general public use to obtain details about the interior of a home was a search under Katz. The home, said the court, is where privacy is at its zenith. United States v. Jones in 2012 is a fascinating hybrid. Police attached a GPS device to Antoine Jones's Jeep and tracked it for 28 days without a valid warrant. The court unanimously found a Fourth Amendment violation, but the reasoning diverged. Scalia's majority framed it as a trespass case. Placing the device on the car was a physical intrusion. Concurring opinions, but not the lead, leaned heavily on Katz's privacy rationale, warning about the implications of long-term, pervasive tracking and the mosaic it creates of someone's life. Then Riley v. California in 2014, smartphones. Police seized a phone at arrest and searched its contents without a warrant, arguing the search incident to arrest exception. The court said no, phones are different. Chief Justice Roberts wrote that they hold the privacies of life, so police generally must get a warrant. That's Katz's privacy logic applied to the digital age. And most recently, 2018, Carpenter v. United States. The government obtained months of a suspect's cell site location information from a wireless carrier without a warrant. The court held that accessing 7 days or more of historical CSLI is a search and generally requires a warrant. Carpenter is important because it limited the third-party doctrine in a meaningful way for location data. It recognized that some kinds of information, highly revealing and generated without deliberate choice, deserve privacy protection under Katz. Speaking of the third-party doctrine, let's make that tension explicit. The doctrine from United States v. Miller, bank records, and Smith v. Maryland, pen register, says you have no reasonable expectation of privacy in information you voluntarily turn over to third parties, your bank records, numbers you dial, and so on. Under a strict third-party doctrine, Katz's promise looks thin. In today's world, functioning in society means handing vast amounts of information to third parties, ISPs, platforms, carriers. Does that mean none of it is protected? Carpenter is a partial answer. The court refused to treat CSLI the same way as a bank record. It acknowledged that the scale and revealing nature of location data make it different. But many questions remain unresolved. Search histories, IP logs, aggregated metadata. Katz provides the analytical frame, but line drawing is hard when digital life forces us to disclose data as a condition of living. Let's slow down and consider some concrete, everyday examples, because that's where Katz really touches people. Text messages and emails. Courts generally treat the contents of communications as protected. Police typically need a warrant to read stored texts or many emails. Smartphones. Riley tells us police generally need a warrant to search the data on a phone seized incident to arrest. Smart home devices. Smart speakers, cameras, thermostats collect intimate details about life inside the house. Katz's logic suggests a strong expectation of privacy here, especially for in-home data, but courts are still figuring it out. Cars and GPS. Jones signaled concern about putting trackers on cars. Long-term location surveillance raises Katz-style privacy concerns. Public but semi-private spaces, bathroom stalls, dressing rooms, closed office interiors, can carry reasonable expectations of privacy, even if technically in a public setting. Katz rejected the absolute rule that public presence equals no privacy. Now, let's take a beat and address common misconceptions. Misconception number 1. If you're in public, you have no privacy. Katz rejects that. You can create pockets of privacy in public by taking steps, closing a door, lowering your voice, using a private channel, and sometimes society recognizes those steps as reasonable. Misconception 2. Any information shared with a company is fair game. The third-party doctrine pushes that idea, but Carpenter shows the court won't apply that rule blindly when the data is especially sensitive or revealing. Misconception 3. The Fourth Amendment gives a general right to privacy in everything. Not quite.
The amendment applies where there's a reasonable expectation of privacy, not to every secret we'd like to keep.
We should also dwell on the deeper tension Katz reveals, the challenge of adapting constitutional doctrine designed in an era of litters and face-to-face speech to technologies that can observe everything without physical trespass. Katz moved the law from a bright-line property rule to a flexible privacy test. Flexibility has benefits. It allows adaptation to novel technologies, but it also creates uncertainty. What is reasonable? Society's views evolve, and judges must make normative calls. There's also a related critique. The Harlan two-part test embeds a lot of judicial discretion. The subjective prong asks, did the person manifest a privacy expectation? That's often straightforward. The objective prong, whether society recognizes it as reasonable, invites judges to evaluate social norms, which can be messy. Is it reasonable to expect privacy in your phone when it's connected to a network? Is it reasonable to expect privacy in a hotel safe? Courts answer these differently across time. I want to pause and bring in a narrative, just to make this feel human small, tactile. Imagine Katz in that booth, late afternoon traffic on Sunset, neon lights, somebody selling papers on the corner, the metallic slide of the phone booth door. He drops coins into the slot. The dial clicks, the line hums. He closes the door expecting to be alone. Across the country, Boston, Miami, someone listens on the other end. And outside, an agent, somebody in a car maybe, or a reel-to-reel recorder in the trunk catches it all through a tiny microphone against the glass. That image captures the wrongness Brandeis warned about. It's vivid. Little aside, interesting trivia. The listening devices measured vibrations through the glass and metal. They didn't need to tap the internal wiring. That technical detail mattered legally, because under the property rule of Olmsted, the absence of physical intrusion meant no search. Katz changed that calculus. Let's walk through a couple of doctrinal forks that Katz created. One path is the original property-based theory, trespass matters. That path resurfaced in Jones, where Scalia's majority opinion emphasized physical trespass in placing the GPS device. Another path is the privacy expectation path, Harlan's test, used to evaluate whether pervasive surveillance, even without trespass, should count as a search. In Jones, concurrences emphasize the privacy problem created by long-term tracking, so both pathways are alive, sometimes converging, sometimes diverging. Why does it matter which pathway courts use? Because the outcomes can differ. A trespass rule might protect against physical intrusions, but leave open many forms of remote or third-party surveillance. An expectation of privacy rule can be more flexible to cover emerging technologies, but also more unpredictable. Carpenter shows courts can blend the two. The court recognized the privacy interest in CSLI, despite traditional third-party rules. Interesting how that plays out, right? Okay, continuing. We should look at the statutes too. Katz spurred Congress to regulate surveillance. The 1968 Wiretap Act set out warrant procedures for wiretaps. Then, as technology evolved, Congress passed the Electronic Communications Privacy Act in 1986 to cover email and electronic storage. But statutes often lag technology. For example, ECPA has oddities, like the 180-day rule for stored email. Statutory fixes help, but they don't resolve every constitutional question. Courts still interpret the Fourth Amendment. Another practical point I like to emphasize with students. Katz didn't invent privacy as some free-floating value. It reoriented constitutional analysis to focus on what the amendment's protections should protect in a modern world. Katz said, the amendment speaks to the individual's expectation of privacy. That's a doctrinal pivot, and it's why the case is in every constitutional law casebook. Let me ask a question out loud, rhetorical but useful. Is our modern reliance on third parties to perform everyday functions, email, banking, phones, compatible with a robust Fourth Amendment? Carpenter suggests sometimes yes, sometimes no. The court is willing to protect certain categories of data because they reveal too much, but many categories remain vulnerable under the classic third-party rule.
That's a live debate in courts and in Congress. You see the stakes: privacy, public safety, law enforcement efficacy. The government often argues that strict warrant requirements slow investigations into organized crime, terrorism, cybercrime. Civil liberties advocates warn that loosening limits slides us toward mass, intrusive surveillance. Katz sits at the hinge of that tension. A few more cases to map the terrain. Miller, 1976, on bank records. No reasonable expectation of privacy because you gave the records to the bank. Smith, 1979, on pen registers. Numbers dialed are not protected. Those are the pillars of the third-party doctrine. Carpenter undermined them in part for location data. Kyllo protected the home from thermal imaging. Riley protected the digital contents of a phone. Jones revived trespass concerns while also feeding privacy arguments about long-term tracking. Each case shows Katz's influence, but also the continuing struggle to apply its principles. Let's be candid. Katz created doctrinal flexibility, and with flexibility comes unpredictability. Law students tend to hate unpredictability, but courts sometimes need flexibility to keep up with technology. The challenge is designing clear, administratable rules that protect privacy without crippling legitimate policing. Katz gives us a conceptual frame, but it doesn't always provide bright lines. That's why statutory law like Title III and ECPA is important, because it can offer more specific procedures. Another brief anecdote: Katz himself is largely absent from public memory. He's not a civil liberties hero. He was an interstate bookmaker. His personal story is thin in the record, but his case reshaped constitutional protections for millions. There's an irony there worth reflecting on. The person whose name we invoke in courts and classrooms is effectively anonymous to the broader public, yet the doctrine named for him touches almost everyone who uses a phone, a computer, or a smart device. We need to talk about what's unresolved. What about data aggregated across sources? Some scholars call this the mosaic theory. Separate bits of non-sensitive data, when compiled, create a detailed portrait of a person's life. Is that protected? Katz arguably supports protection, but courts vary. What about algorithmic inferences? If companies infer something sensitive about you from metadata, do you have an expectation of privacy in those inferences? Katz provides a vocabulary for asking the question, but not a definitive answer. Consent is another sore point. If you click "I agree" to a service's terms, have you truly waived your expectation of privacy? Courts often treat that as voluntary exposure, but critics argue that consent buried in lengthy terms is not meaningful, especially when using a service is a necessity of modern life. Katz's test depends in part on whether society recognizes the expectation as reasonable, so that raises normative questions about the role of consent and the marketplace of services. Short turn. Okay, so where do we go from here? First, we should recognize Katz as a living doctrine. It's not an old chestnut you cite and close the book on. It's the foundation for ongoing debates about location data, home devices, and the surveillance capacities of AI. Second, legal actors, courts, legislatures, agencies, must continue wrestling with how to balance investigative needs and privacy. And third, citizens should be aware. Every time you assume privacy, closing a door, locking a phone, you're relying on Katz's framework to protect you. Now, let me close with a reflection. Katz asks a timeless question. When technology can observe everything without a physical intrusion, what privacy remains? The court in 1967 answered by centering the person's expectation of privacy and recognizing that society may treat certain expectations as reasonable. That approach has allowed the Fourth Amendment to adapt, sometimes haltingly, to new technologies. But the work is not done. PAFS gives us vocabulary and a compass, but not a map that plots every twist of future surveillance. So, what should you take away, especially if you're a student or a practitioner? 1. Learn the Katz two-prong test cold: subjective expectation and objective reasonableness. 2. Understand the third-party doctrine and its limits. Carpenter shows it's not absolute.
3. Watch how courts handle aggregated data, algorithmic inferences, and ubiquitous sensors. These are the next frontiers. And 4. Remember the history. Olmsted's property approach was overturned because it didn't track technological change. Law must be able to do the same, but thoughtfully.
Final short thought. Katz is a reminder that cases with small, specific facts, a man in a glass phone booth, can trigger doctrinal revolutions. Law is often made in details. That's it for today. Thanks for listening. I'm Elena Park. If you teach Fourth Amendment, use Katz. And if you practice, keep watching the lines courts draw. Until next time, stay curious and keep asking what privacy means in our age.